The Ninth Circuit rules that magazines aren't protected arms. Plus, the 11th Circuit upholds Florida's gun sales ban for young adults. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter. It'll keep you up to date on all things happening in the world of gun politics and policy. This week's episode is also brought to you in part by The Dispatch, but more on that at the end of the show. To kick us off this week, it's been actually a pretty jam-packed week as far as court rulings go. And one of the bigger ones was the en banc Ninth Circuit finally handing down its final decision in the Duncan versus Bonta case, the case dealing with California's ban on so-called large capacity magazines. And I think to most observers of this space, there's not particularly surprised to find out that the court upheld California's ban.
Yes, unsurprising, I think, is a good word for that, because this is the third time they've done this.
Yes, second en banc opinion and third overall Ninth Circuit opinion on this specific ban.
The Supreme Court has already gotten involved here once, but all they did was grant, vacate, and remand the case back down in light of Rahimi, right?
Bruin. It was after Bruin.
Okay,
yeah. So
we're going back to the GBRs from Bruin. But we got a final decision now. It's one I think everyone probably expected, given the makeup of the Ninth Circuit. It was 7-4, I believe. And they didn't really break any new ground, right?
Yeah, that's it. In fact, literally, it was the same exact margin as pre-Bruin. So the whole concept of the GVR was, hey, we have a new methodology now, so redo this case. Mm-hmm. And surprise, surprise, same exact outcome, same exact vote margin, and nothing changed.
None of these GVRs have really produced much new in the way of court opinions on these really high-profile cases, at least.
Yeah. But instead of explicitly interest balancing this time, the rationale in this opinion was that under the plain text of the Second Amendment, which is the first thing you're supposed to do under the Bruin test, the court said that magazines don't count as arms under the Second Amendment, as spelled out.
Yes, they're accoutrements, right? Is how they describe them.
Yeah.
So basically accessories. And the idea is, as far as I understand it, is that they're saying that because you don't need a magazine that holds more than 10 rounds to functionally operate a handgun, a semi-automatic handgun, because you can use magazines that hold 10 or fewer rounds, therefore magazines that hold more than 10 rounds are not protected by the Second Amendment. That's the core holding here, right?
Right.
But they did get into, well, even if they are protected, you could still ban them with a Bruin analysis, right?
Yeah, it's something you've seen a few courts do in this case where they say, well, we could have just stopped right there at the textual prong, but we're going to do a historical analysis anyway and double show you that we're right. And in this case, they said another familiar argument, magazines represent a dramatic technological change. So that allows for us to take a quote unquote more nuanced approach to the history, which they're citing a piece of dicta from Bruin in that case, which essentially means they're allowed to be pretty loose with the historical laws.
That's how they interpret it, at least.
That's how they, you're right. That's how they take it. And they essentially said that founding era gunpowder storage laws, so restrictions on how you could store gunpowder, as well as trap gun bans, so guns that are meant to, you set them up so that they can fire if someone trips a wire or something like that.
Yeah, the old movie trap gun, somebody walks through a door and a shotgun shoots them, that sort of thing.
Yeah. So those restrictions on those around the founding era were similar enough to California's modern magazine ban, because the argument goes they were meant to prevent harm similar to the way that magazine bans are meant to prevent mass shooting harms, broader harms. That was their point.
Mean, certainly that's one of the stretchier arguments I've seen in the federal courts on that gunpowder storage laws are similar in at least the why for magazine bans. I mean, magazine bans, at least the argument is that they'll help prevent or reduce mass shootings, whereas gunpowder storage laws were to help prevent fires. So it's very hard to. They claim, they're saying like gunpowder storage laws, these are similar because they're meant to prevent spontaneous mass casualty events, right? And so they're really stretching the similarity argument there. And then they had another one too, right?
Yeah, and then another familiar one is Bowie knives.
Yes.
You take those at the founding era, but then they go to 19th century laws, usually restricting carry of Bowie knives. They're fairly common during that period because people thought that Bowie knives were associated with criminality, and so they would restrict your ability to carry them in public. And they said, that's another example of a continued tradition of, quote, restricting weapons associated with criminal intent.
Right. Of course, are magazines that hold more than 10 rounds associated with, most people that own those are not going out and killing people. But yeah, that's the basic argument. That's the breakdown that we've seen it before. It's not a new argument as we're getting at here, right? But obviously a setback for gun rights advocates in the immediate sense that they lost this case, right?
Yeah,
not an unsurprising
period,
thing, but
not unsurprising, but point blank period, it sets a precedent in the largest circuit in the country that magazines aren't even arms. And so, states like Washington and Oregon and Hawaii that are all in the Ninth Circuit, they also have magazine bans. So presumably those are now constitutional. But it may not be a permanent setback because, as we mentioned, this case has sort of boomeranged up and down the courts so far. It's got one of the most developed case records of any quote unquote hardware ban case.
That's for sure.
So it's a prime candidate, I think, for Supreme Court review if the Supreme Court wants.
If the Supreme Court wants to do anything with it. And in fact, today they are once again considering the Snope case, and I think was it Ocean State Tactical.
Ocean State Tactical,
which are hardware ban cases. Snope is out of Maryland for their assault weapons ban, and Ocean State is a magazine ban out of what state is that?
Rhode Island.
Is Rhode Island? Why is it called Ocean State? Ocean State. Is Rhode Island? I don't know. They're known for being an ocean state. Anyway, regardless, I don't know why the company chose that name, but that is the magazine ban. So, in theory, the court could undercut this decision in Duncan tomorrow if it wanted, or it could take up a case that's pretty much identical if it wanted to. Although, like you said, Duncan is much more developed. People have been waiting for this case to get to the Supreme Court and for them to take it for how long has it been now?
It's been an 8-year case. 2017 was when the first complaint was filed.
So, kind of an example there of how the courts move. Court speed is not normal people speed. And this is where a lot of gun rights activists will get upset at how slow the court moves on some of these things. And I just sort of described an example of that. Snope has gone through this several times as well. But the court has been to this point, at least in what we're hearing from some of the justices, especially the more conservative justices, is that they're really taking a wait and see approach. We want to see all these cases developed in the lower courts before we weigh in. Now, whether that's just cope on the part of this conservative justices who are in those same statements and dissents from denying cert, are whether that's just cope on their part because they're already saying they would take these up and they know how they would rule, and I guess they don't have 4 votes to do that yet, or if that is legitimately what the court's waiting for. They just maybe don't want to move super fast on these things until their decisions in Bruin and Rahimi have percolated a bit more in the lower courts. We'll see how it'll be hard to know because we won't know for years in theory, because they could deny Snope, and that doesn't necessarily mean that they agree with the lower court ruling. It just means they don't want to take Snope right now. So we'll see. But either way, Duncan provides another avenue if they don't decide to take up one of these 2 cases. They're hearing for, I think it's the 8th time.
It's getting hard to keep track because it's been a while. A lot of relists. I think it's been at least 5 or 6 relists, and
I think it's
maybe 7th or 8th.
Most of the time that, from what I've heard from litigators on this, that's usually a bad sign for the plaintiffs, because it usually means that they're going to deny and they're just waiting for someone to write a dissent. But that's not always true, right? Sometimes it can be, especially like Dobbs. I think there was like 13 relists, the case that overturned Roe v. Wade. So I don't know. We'll see. The court, you can only take what they give you, and they don't give you very much a lot of the time.
Yeah, certainly. But sticking to the Ninth Circuit, we also had another Ninth Circuit ruling this week, this time dealing with Hawaii in one of their more novel, I would say, gun restrictions, even as far as some of the more restrictive states go. They had a requirement. They have a permit to purchase requirement for handguns, and attached to that requirement is that after you get a permit, you have to purchase your handgun within 30 days. It used to be 10 days when this case was first filed, but they made it 30 days. And then after you purchase it, you have to take it within 5 days to the police station to have it inspected, I guess. I'm not sure what they're supposed to get from that, but the Ninth Circuit in this case said that those were unconstitutional under the Second Amendment. Yeah.
So Hawaii lost again in court. Now they tried to moot this case a couple of times by slightly loosening these requirements over the course of this case, but they weren't successful because the new restrictions this panel ruled that the new restrictions were just as arbitrary as the old ones. And so, although one interesting thing about this case is there was it's 3 Republican judges in the Ninth Circuit, and one of them dissented. So it'll be real, the Ninth Circuit has a tendency to take up all Second Amendment cases to on banc, not literally all of them. There's one that they didn't do that for just recently, but almost every other one has gone there. And then just like with Duncan, we just saw the court has always ruled with the government and never with the Second Amendment plaintiffs. So the fact that you got a Republican dissent and that it's the Ninth Circuit and Hawaii is probably going to request an en banc review spells maybe bad news for this case moving forward, even though so this example of, good news. This is a positive development for gun rights activists having won this case. But just like Duncan was a negative immediate news, but could have positive outcome down the line for the plaintiffs, this is the opposite of that, where it's positive immediate news, but the signs are that it could have negative ultimate outcome down the line. And by the way, we didn't mention this. So we know the stat of what is it? That we know that the Ninth Circuit has never ruled on the side of the Second Amendment plaintiffs at the en banc level, the full court, because of a dissent from Justice VanDyke, right, or Judge VanDyke, in a previous case. And we didn't mention this, but we should probably talk about it a little bit because it's gotten a lot of attention. Judge VanDyke did a dissent in Duncan as well, as you would expect, because he's been a very ardent pro Second Amendment judge in his time on the Ninth Circuit. But he did something a little bit different, and he's known to do this, right? I think in a previous case, he wrote like a mock opinion for the majority where he's like, I know what you guys are going to say, and I'm kind of going to make fun of you for it, basically. Right. And this time around, he made a whole video to go with his written dissent, right? In the Duncan case, the magazine case.
Yeah, this is what's capturing all the media attention because he did a written opinion and then he included a link in the middle of it. And if you click the link, it takes you to YouTube, and it's a video of him in chambers, in his robes, and
with a bunch of guns.
with I guess personally owned handguns. Yeah. Uh-huh. And an AK-47 on the wall behind him, or what looks like an AK-47 on the wall behind him. And he's essentially just, trying to demonstrate how magazines work and trying to make his broader point about the necessity of magazines to the function of a firearm. Yeah. And this has ignited a firestorm.
Yeah, it's kind of wild. It's sort of like people are much more upset with him over the format of delivering his opinion in this case than anything else. Which is, I mean, it's definitely highly unusual. I've never seen a judge do this before, right? And I think one of the judges in the majority accused him of trying to play act as an expert witness without having to follow the rules of that would come along with an expert opinion being offered in a court case. But I don't know. honestly, it just seemed like he's demonstrating his point by using actual firearms in a visual medium instead of written. He could have just written this out, certainly. And I think it gets a little bit, it's like 20 minutes long. And his basic point is just, we talked about the majority's holding, which was essentially that magazines that hold more than 10 rounds aren't arms protected by the Second Amendment because they're not necessary to the operation of the firearm, because you can get a magazine that holds less than 10 rounds and the gun will still operate. It'll still function. And so his point that he's making in this video, using, his actual firearms as the props, or like to demonstrate his point, is that you could make that same argument for pretty much any gun part. Right. That's what he gets at in this video, and he uses a SIG P320, which, is a modular design. So you can literally swap out pretty much anything on that P320 for any number of different options. That's one of the big appeals of the 320. Although there's downsides that the SIG we didn't even talk about the wild SIG video or a SIG press release they put out last week on trying to defend the 320, but it's sort of ancillary to what we're talking about here. But he uses a 320 because it's a very, presumably because he likes it, because he owns several of them, including, according to this video, he's got like 10 different grip modules for this SIG, and he's very capable at manipulating the firearm. But he makes this point of like, well, under the majority's reasoning, you could, even the semi-automatic action is not necessary for, for you to have a functioning firearm. You could even use something as basic as a break action single shot gun would still be a functioning firearm. And so he's trying to make the point here that under the majority's reasoning, there's no real, the limit for this argument is that you could ban almost any gun and not have any impact on the Second Amendment. That's what he's trying to, that's his critique that he's trying to get across. And he uses this video to taking apart this 320 and showing the individual parts and how he has, the sights could be replaced with a red dot sight. So, because, the gun will still function without the red dot, is the red dot not part of the arm? And then he goes to basically every part of the gun. The grip can be swapped out on a 320. Even the trigger can be swapped out on a lot of guns. Right. And so you're kind of, he's making this point that you can, under the majority's reasoning, you could ban every component of a firearm, but the very most basic version of it, and still not implicate the Second Amendment at all. That's what he's saying the majority opinion leads to. Which is kind of, to be honest with you, is not really the core of the dissent to these decisions, right? It's not really the main point that the dissenters have. It's just sort of an ancillary point about the logic being used by the majority and one of the flaws in it, from his point of view, right? But it's gotten all the attention because he did it on video and he used his own guns to show it, which has been kind of interesting. In fact, I'm going to be on CNN later today in the 3:00 hour. At least that's scheduled to be on right now. It's cable news. It moves very fast and it may not happen. But that's what I'm scheduled to go on and talk about this. So it's certainly raised interest. It's piqued everyone's interest. But it's kind of a fascinating thing for him to do. I didn't really see any, he's right. Everything he says is factually accurate in the video. And he clearly knows firearms, pretty well. He's probably fairly unique in that. So even a lot of the pro-gun judges aren't necessarily gun guys, if that makes sense. VanDyke is clearly a gun guy. He has a competition gun and a carry gun and a bunch of other firearms. So that's pretty unique, I think, in the federal judiciary. And it was interesting to see him break with tradition, at least. I don't know that he violated any sort of ethical rules, but he certainly broke with tradition to do a video over just the written dissent.
Yeah, that's the thing, is the legal profession is a very small C conservative profession. So anything that deviates from the, I think that's what it was. And just really his background, like you mentioned at the top there, his background.
Yeah, the visuals of it.
Colorful dissents. And so because of who he is and the fact that he did this novel opinion, I think, has captured a lot of media attention. But
yeah, and the visual aspect of it helps too, like
right.
him handling firearms in his robe in his chambers. It's
right.
Like it's sort of people are upset by the symbolic nature of that, I think, more so than what he's actually arguing. Because I don't know that he's really presenting himself as an expert witness. He's just kind of describing what he thinks is the problem with this, with the majority's like argument.
Right.
He's taking it ad absurdum. Is that the right way to pronounce that? I apologize if not. He's going to the extreme end of what the logic they're using could justify, which is a common debate tactic. But yeah, so certainly a fascinating thing to come out of it, and got by far the most attention, even though the opinion is going to have like a significant impact on everyone who lives in those states, which is a huge number of people. We're still focused more on the how this one judge presented his dissent on a specific point.
And he wasn't even the primary dissenter. Yeah, no. It's a funny thing that's what's capturing the.
I mean, I get it. It's unusual. It's different. It's not what you expect to see from a judge in a federal court case, but he doesn't say anything that's wild in there necessarily. It's just sort of the format of it that's gotten people to really pay attention. Yeah.
But sticking on appellate judges, we actually had another major appellate ruling this week, this one out of the 11th Circuit. And it's the sort of long-awaited final decision on Florida's post-Parkland age limit on firearm purchases.
Yeah.
And the en banc 11th Circuit actually upheld that law as constitutional.
Yeah, this one kind of surprised me. I wrote 2 years ago after the panel decision, which also upheld the age restrictions in Florida, that that law probably wasn't going to last long, because I thought that, one, there was a lot of political will to undo it, with Governor DeSantis backing the idea that it should be repealed, and Republicans well in control of the legislature there. But they haven't done that. It's still on the books. No one has actually gone through with repealing this, and that doesn't feel like there's any political will, or at least enough political will, in the Republican Party in Florida to overturn any of these post-Parkland gun laws that they passed at this point. I mean, it seems like they're not going anywhere, because they even, they passed permitless carry before they undid this. So, turns out there's not much political appetite for undoing these restrictions from Parkland, even while they're undoing other gun restrictions. And then, I thought that the argument they used at the panel level, the 3-judge panel level, was not going to be, win the day at the 11th Circuit, the full en banc hearing. And to be fair, I was right about that, because the lower circuit relied much more on laws from later in American history, from the after the Reconstruction era, basically. Like, significantly, there was a significant distance between the founding era and the laws they were using to claim a historical tradition to uphold the age restrictions in that lower panel. And so we actually got a quite different argument from the en banc panel, right? Because they focus much more on the founding era, but in a different way, right?
I say it's something that's come up in a lot of these age restriction cases, but this was, like you said, more of the core holding focused on the fact that at the time of the founding, around the time of the founding, people under the age of 21 were often considered minors for purposes of other legal regimes. They weren't considered full adults with full rights, and so that was sort of the hook that they got into to say, look, there's a tradition of recognizing that these folks don't have full rights. And so in this case, it's constitutional to restrict their access to firearms.
Yeah, they use this argument that essentially the age of majority, as it's called, basically adulthood, at the founding was 21. And so people under 21 couldn't enter into certain contracts without parental permission, and couldn't do a bunch of things. And they extended this to claim that they couldn't buy guns at the founding. Because this law, remember, these age restrictions are not about possession of firearms. So people under 21 can possess firearms, but they can't buy them. That's what the restriction focuses on is the sale or purchase of firearms. Like you cannot sell guns of any kind to those under 21. Now there's already a federal restriction in place on the sale of handguns to people under 21, but not long guns. And so this Florida law extends that to just all guns, but it doesn't ban possession. And so that was another key thing they focused on they stuck with this idea that even though there was no specific law that they could find to note that those under 21 couldn't buy guns, they extrapolated that must have been the case because of all these other restrictions on entering into certain kinds of contracts and so forth that existed for people under 21 at the founding. And so that's where they came down. They relied very heavily on that idea instead of relying on later explicit age restrictions on gun buying or carrying or what have you. So that was interesting, and I think that is a stronger argument certainly than the lower panel had, but it wasn't one I was expecting to see the full. The 11th Circuit is not the Ninth Circuit, right? I mean, Florida is in the 11th Circuit, and so you'd expect it to be a bit more of a conservative circuit here. And the judge, I believe, was a Republican appointee who wrote the majority opinion. So that is kind of a surprising outcome, at least to me. And so, it's definitely one that also perhaps creates a bit of a circuit split. Not on the like the Florida law obviously isn't going to be ruled on by any other circuits. And I don't think there's been a law like Florida's that's been ruled on, certainly not at the appellate level yet. But we did just have a panel rule on the federal handgun ban for those under 21, right? And
so we had the Fifth Circuit and then also the Third Circuit, the emergency carry for under 21s in Pennsylvania. So you've got a few of these, and it's another one of these sort of Supreme Court bait topics, and whether or not they want to jump in. And this is where you have much more of an actual split. Now, these restrictions are not all the same. Like you just mentioned, the Pennsylvania one is not, I think that was Pennsylvania, right? But it's Third Circuit either way. That one's about carry during emergencies and not sales, and then the Fifth Circuit one is about handgun sales in particular under a federal law, but they all deal with this similar question. Generally the question is, do those between 18 and 21 or 18 and 20 have a right to have Second Amendment rights? Are their rights protected by the Second Amendment in the same way other adults are? And so now I will say that the Florida, one of the interesting bits from the majority opinion too, because a lot of the plaintiffs in these cases and the dissents in this Florida case focus on 18 to 20 year olds, right? That they're adults, and sort of the argument is the big argument is that at the founding, 18-year-olds had to bear arms as part of the militia. Like it was required under law that they bear arms, and so they would have had to show up with their own firearms. So it sort of implies that they could buy firearms. The majority rejects this idea, claiming that it would really be their parents would have to arm them. They couldn't go out and buy their own guns, is the claim of the majority. But the other half of it, the majority says, well, you're claiming that 18 is when because we've changed some things about, when people get certain rights of adulthood from 21 to 18, that, it should be 18 to 20 year olds should be included in the adult category now. And they were saying like the law, I don't know, he made I know the majority makes a big point about, the law doesn't, they don't address like why the cutoff should be 18 and not something lower than that. And they're arguing that it should just be that 21 because that was the age of majority at the founding. And there hasn't been enough change to the status of 18 to 20 year olds since that time for it to make a difference as far as the Second Amendment is concerned.
So, I don't know. Obviously the majority here wants to focus on anyone under 21 all the way down to toddlers, right? And the dissent and the plaintiffs want to focus on just 18 to 20-year-olds because most people now consider 18-year-olds to be adults, regardless of what the founders considered adulthood to start at. So I don't know. It's certainly going to be one of those cases that has a better shot of getting to the Supreme Court at this point because of the interesting difference in the circuits.
The interesting piece on that, too, is what the Florida Attorney General said about that, sort of echoing that point in the dissent, is he came out after this decision was handed down and said, should the NRA, who is the plaintiff in this case, decide to try to bring this to the Supreme Court, he said that his office wouldn't defend the law at that level because he believes, like you kind of articulated there, that he believes 18-year-olds, if you're old enough to join the military, et cetera, all these other things that we consider them the age of majority for, he thinks that they should be able to, as a political matter, be able to bear arms as well. So he's committed, at least at this point, to not defending that law if it goes to that next level.
Yeah. So the politics of it are very interesting in Florida. There doesn't seem to be appetite for repealing this law, but also they don't, I don't know if they want to be defending it either. Right. So we'll see if it makes it up to the Supreme Court or not. But we just have a couple of quick headlines here, and then we're going to go to we have a new segment with active self-protection, where we're going to look at one of their most interesting videos from the last month or so, and got Mike Willever on to do that. So we're going to keep this part of the show a little bit shorter so we don't go too far over time. But let's just roll through our headlines section real quick.
Yeah, we had an interesting one from Cam Edwards over at Bearing Arms, and it'll be a nice little hook to our main interview podcast this week. But he remarked on the fact that the Department of Justice filed a brief in the U.S. v. Peterson case in the Fifth Circuit dealing with whether or not silencers are covered under the Second Amendment. In which case,
whether they're arms, right? Same discussion.
Similar with the magazines.
Yeah, the Duncan case.
And the DOJ in this case filed a brief saying that silencers are not arms as considered by the Second Amendment. And Cam was talking about how that aligns with the Trump administration's executive order and wanting to review positions on certain things.
And we just got news on this, right?
It is interesting that, shortly after he wrote this piece, the DOJ actually filed another brief saying, hey, can you actually put this case on hold? We want to actually discuss and review if we want to, take that same position. So pretty quick turnaround.
Pretty fascinating. And we're going to be talking about with Cam at length, the new rule that the DOJ just handed down in regards to gun rights restoration, the process there, trying to sort of reignite that down the line at least. And so he's going to, and then also the appointment of Professor Robert Leiter, who's been a guest on the podcast in the past from George Mason University, to head up the ATF's chief counsel office. So he's the chief counsel of the ATF. That I think that's even bigger news than the rule that they published this week. So we're going to talk in depth with Cam about that.
Yeah, certainly. And then just one other quick link we wanted to mention, sort of related to the Trump executive order and the administration's moves, is that they've taken down at HHS the previous, gun violence and public health emergency, I think was the declaration under Biden's Surgeon General. And they've scrapped that. And the comments they've made is that it's related to the Trump administration's attempt to support the Second Amendment. Which is
a little weird because the executive order doesn't actually refer to HHS.
Right.
It's for the DOJ, but this is one of those things that, you could just do because there's no rulemaking, or you don't need to change statute or send a different brief in for a court case or something. You can just do this though. Like it's just a report that was posted, a fairly political one, frankly, to be straightforward about it. It calls for like assault weapons bans and stricter gun laws by the Surgeon General. And so that doesn't align presumably with the new leadership at the HHS view on these things. And so they can just remove it if they want to, similar to how they from all appearances have gotten rid of the Office of Gun Violence Prevention at the White House. Is another thing where it's just well within the president's power. They don't have to, there's no sort of controversy or fight over it like there are with a lot of the other things they're trying to do. this is something where Biden created it out of whole cloth. You can remove it out. These wasn't created by statute, or there's no real, fight. Didn't go through the rulemaking process. This is just something the president can do. And there's still more things he could do that he hasn't done yet. And we'll get to that with Cam. But for now, I'm going to hand it off to myself to talk with Mike. Okay, folks, we are here with this new segment we're trying out. This week, we've got Mike Willever from Active Self-Protection. For those of you who don't know, he was actually on the show a little while back, right? On the podcast, talking about the time he responded to an active shooter incident.
That's right.
Mike has spent a whole career in federal law enforcement, right? And now he works over with Active Self-Protection. He does their podcast where they do, where he does fantastic interviews of some people who've lived through self-defense situations, like life and death situations where they've had to defend themselves. And then he also does another smaller podcast about gun news with me called the Gutowski Files, which you guys can check out. I would encourage you guys to take a look at those and also at Active Self-Protection Journal. Mike, why don't you just give us a quick overview of what exactly, for anybody who's not familiar with it, what Active Self-Protection is?
Well, essentially, John started this channel about 15 or so years ago based on an incident that he saw where someone was stabbed in a brutal attack, and he wanted to workshop that idea with his jiu-jitsu instructor because he didn't know how to defend against it. And that turned into him posting that on his Facebook page, and that turned into a YouTube channel, which now has something like 3.5 million subscribers. And the idea is we like to give evidence-based examples of self-defense incidents. So every day on the channel, there'll be a video from somewhere around the world. It could be surveillance video. I'm on twice a week, Tuesdays and Thursdays, where we break down badge cam and dash cam video of real life police encounters. And we will give our 2 cents on if we think it was justified, tactics, what could have been done differently and or better. Of course, for those who don't know who I am, I was a 25 plus year federal agent, defensive tactics instructor, firearms instructor, active shooter response instructor. I did all kinds of fun stuff with them. Prior to that, I was a police officer in 2 different places. So a lot of varied experience, a lot of street time for a Fed. Most Feds spend, 75% of their time in an office. I'd say mine was 50-50 office to street work. And I appreciate the viewers and listeners who pay their taxes, who paid my salary. I really appreciate it.
And, Active Self-Protection has basically created this repository of real world caught on video self-defense incidents or shooting incidents or fighting incidents, not always self-defense, but all kinds of different incidents, anything that you can really glean some takeaway from. And, I think you've become, in my opinion, the best resource for self-defenders, whether they're carrying a gun or not, that exists out there, because you guys are looking at stuff that happens in real life on video, not just theory, right? Not just, if you get, I think this is the right way it would happen in theory if I was to encounter a life and death. No, these are videos. You can see what happens, and you can learn from what happens. And that's the core of active self-protection, right?
That's the idea. And for folks who, being former law enforcement, I think a lot of people tend to think that someone like me would be more sort of pro LE or more apt to side with law enforcement in any situation. If you go look at our channel, we call balls and strikes to the best of our ability. And that's on the regular self-defense videos and on the law enforcement related ones where, look, there's plenty of times where like, hey, the officer, the deputy, the agent involved in this was in the wrong, or this shooting was not good. We say that with some regularity to the chagrin of a lot of people who, it's funny, our videos are frequently a Rorschach test for people. They look at it and they see it the way they want to see it, and then they either agree with us or don't. And so half the comments say we're completely wrong, and the other half say we're completely right. Half the comments say we're anti-LE, the others say we're too pro-LE. So it really comes down to, I think, people's perspective. But yeah, we try very hard to get on the middle. And if we're wrong, which we've been a few times, we'll redo those videos and we'll say, hey, you know what? The comment section spoke, and we looked at it again. And we were right. We were off a little bit. So we try to amend the ones where we missed the mark a little bit. But for the most part, I think we're pretty good and on the nose.
And that's why I like you guys, why I like active self-protection, why we do the podcast together, and why I want you guys to be on our news update here, occasionally to give us the best of what's going on over at ASP, to give us a little update. Because I think we take a very similar approach to what we do in that, it's based on expertise, based on, real world events, but also, on the idea that we're trying to serve the audience. We're trying to give them a fair view of what we believe is going on and trying to give them the best analysis possible. So, and that's the idea with this segment, is just try to find other people who are making great stories, great videos that are in that gun realm, but
Sure.
have an expertise that's beyond what we have at the Reload. Like, we don't do self-defense analysis, video analysis, fight analysis stuff here, but you guys do, and you guys do it really well. We don't do gun reviews, but Humble Marksman does those really well. We don't do gun history, but Forgotten Weapons, Ian does that. So I'm hoping to have folks like that come through and do these segments, when they're available. Just give us an update on what's going on in their worlds. Cause I think, you guys make great videos, and I think our audience will enjoy hearing about some of them. Speaking of which, this week we are going to talk about maybe something that's might strike people as a little bit controversial, right? There's a sort of idea that you see commonly out there in media or on the internet that, if somebody is unarmed and you shoot them, that you are inherently have done something unjust, that perhaps illegal, right? That it's just never justified to shoot an unarmed person. And that is perhaps something that I think maybe I think you would argue, as certainly in this video, is a bit disproven, right?
Yeah, I think that, look, are there times when the police are in the wrong and they shoot somebody who's unarmed and they're just flat wrong? Absolutely, it happens.
Yeah. Or self-defenders, right?
Yeah, there's times
civilians as well.
For example, when someone gets shot, quote unquote, in the back, and there's a hue and cry about that because, well, he shot him in the back. In the old Westerns, you don't shoot a man in the back. Well, it could be that person just, spun around, took a shot at the police and held onto his gun and kept running, at which point, yeah, they are justified in shooting him whatever target presents itself, because they have to stop that person from continuing their flight and then, kidnapping someone or carjacking someone. Mm-hmm. Similarly, there are times when someone is quote unquote unarmed. However, the shooting is justified. One of the examples from the podcast is we had an Arizona state trooper who was, stopping someone for a relatively minor pedestrian stop, for a relatively minor offense. And it ended up on a knockdown drag out. And the trooper was being beaten to the point where he was losing consciousness, at which point he shot and killed the assailant. Yeah. So there's a bunch of different ways in which it could be potentially justified. I think this video particularly is a great example of how much can the officer or deputy know in the moment that he pulls the trigger, and how does that affect his or her decision making? Yeah.
So let's get to this video. This is an incident out of Florida.
Yep.
Where we have some, and look, just so people are aware, this is because it's not something we normally do on the show, but we're talking about a real world shooting incident here. So viewer discretion is advised, right? There's going to be some cursing. There's going to be, shooting. And, if you're not comfortable with that, please, don't listen to the rest of this episode. We're going to get into that. We're going to go through it. So just be aware of that. So anyway, we're starting off here with the officer arriving on the scene. So let's watch that.
Where's he at? Who's hurt? Who's hurt?
All right. So, that's a quick clip, but I think there's an important point here, right? That you guys make and we're not going to recreate your video. I think there's going to be some stuff that people should go back to the active self-protection video for at the end of this, but just we're going to do a quick overview of it, right? But there's an important point from this first moment that this cop arrives, right? What's your takeaway?
Yeah. So understand that the officer, this deputy, I believe in this case, is Jacksonville. Excuse me. I think Jacksonville has a combined sheriff's and police department. So I may use the word officer and deputy interchangeably, but this officer deputy shows up. He's been given information from dispatch. Information from dispatch can be extremely accurate and give you all the information sometimes. Sometimes it's inaccurate. It depends on the reporting party, what they said. Did they describe the person properly? Did they give you all the information or not? And frequently you don't have all the information. So knowing that you may not know some of the things going on is part of your calculus as you arrive on a scene. The scene's fairly chaotic. It's certainly nowhere near as chaotic as some of the scenes I've rolled up on, or you'll see in other videos on active self-protection. But, people are sort of yelling and they're pointing in a direction, and all the information you have is there was somebody involved, maybe there's a knife involved, and, they're pointing in that direction. So you could stop and get information. But if you are under the impression that there's someone injured, potentially bleeding, you don't have a lot of time to stop and really get everything straight with the initial encounter with the people that you encounter initially.
It's a chaotic scene.
Yeah, you got to go and figure stuff out as you go. And that's kind of what he had to do here.
And so that's what the cop is showing up to. He's got reports, stabbing, dog is killed. People are telling him it's wild at the scene, right? And so next thing to know here, real quick, is that you see it's hard. It's a bit hard to tell, but that is somebody laying on the ground on this grass who has been stabbed, right? I believe it's pixelated in the video,
right?
So you can't see it directly, but that's appears to be what's going. He's walking up. He just arrived. The chaos of the scene. Now he's seeing somebody laying on the ground who's been stabbed, right?
Yeah. So then the question is, what frame of mind does that put this deputy or officer in? And another point I want to make is, I think a lot of people might think, well, holy crap, this guy's on the ground. He's bleeding. Why doesn't the deputy stop and assist or apply a tourniquet or do something medically to help him? The reason for that is, right now you have an unknown quantity out there. You have a bad guy who's already done someone harm. He stabbed this person. This guy is either dead or in the process of dying. There's a dog. I never see they reported there was a dog who was stabbed and killed. I didn't see the dog during the video, but now you're thinking, okay, two things. I've got to get to the bad guy and get him in custody or neutralize him in some kind of way so that we can safely get paramedics here to treat this person, or I can start treating this person without worrying about a knife being plunged into my back while I'm applying a tourniquet. So that's first.
And he doesn't know where this suspect is at this point. You can tell from the video, he doesn't know. You can't see anything in the video at this moment. He clearly hasn't spotted this guy yet. Right. So, he's priority at this point is to secure the scene, is what you're saying?
Correct. Yeah. And you got to do that before you can lend medical assistance. I talked about the active shooter scene that I rolled up on. It was at a gymnasium for underprivileged kids. It was late at night. It was like a boxing gym. Yep. And I had to, as it turns out, as I ran in, gone out, the bad guy had disarmed himself and was probably ran right by me. But I go in there and there's people in various states of, they're bleeding. All sorts of terrible things are going on. And I've got to sort out, okay, well, is there a bad guy still here? I got to deal with that first before I can attend to the wounded. Yep. And so he's thinking at this point, there's definitely someone who's almost certainly armed, who almost certainly has now shown their willingness and ability to inflict deadly harm on someone else. I got to go find him. And then we get this guy popping up. And this is not that uncommon. Yeah. This is typical criminal behavior. Like he's laying in the bushes for some reason. Who knows why, but here we go.
Put your hands up. Put your fucking hands up. Put your hands up.
Fuck you. Stop my dick.
Get back. Get back right now.
This is where the shooting is going to occur for anyone who wants to.
Get on the ground. Get on the ground. Oh.
All right, so I think we can stop sharing the screen there for a bit. Okay, so that's the incident. That's the core of what happens, right? He walks into this chaos. He sees somebody stabbed laying on the ground. He finds this guy laying in a bush, clearly, not well, incoherent, not compliant at all with what he's telling him to do. He attempts to tase him first. The guy is clearly not. He doesn't have a gun necessarily. He's shirtless, no gun in his hands. We don't know if, he has shorts on. We don't know what's going on, if he has something in his pocket or whatever. But, his first attempt is to try and tase the guy to get him under control. That doesn't work. And then the suspect does not like that, grabs a bucket, throws it at the officer, who then pulls his gun. And the suspect, after throwing the bucket, charges him. Then the officer finally fires several shots, which incapacitates and I think later kills the suspect from your video. And look, I guess the core question here, right? The guy is not outside the bucket. He doesn't attack the officer with any sort of weapon, as far as we can tell. And so the question becomes, well, was this really deadly force? And the first time I watched it, I thought, oh man, that might be a little bit questionable. If he's not visibly armed. I also didn't notice that the pixelated stabbed body was in the first video. So that maybe was changing my calculus looking at it. But, you watched that whole thing play out. What you and John both felt like this was actually a pretty clear-cut case of a justified shooting.
Yeah. So listen, I'll say this off the bat. I completely understand how people could look at this either way, how they could watch this series of events and come to a different conclusion than we did. My conclusion is based on years of experience, and it's based on what a reasonable person, so the standard a law enforcement officer is held to in the United States is, what would a reasonable officer or deputy do in this situation? He rushes him with the bucket initially. It's a tin bucket. It's not much. It's certainly not, I wouldn't consider that a deadly force,
right.
issue. Where
not on its own. If you just show up and someone throws a bucket at you, probably not justified in shooting him. He
comes at him. What do we know? We know the guy was at some point armed with something sharp, almost certainly, and that he's murdered someone or attempted to murder someone, maybe a dog as well. And now he's uncooperative, and now he's charged you with a bucket, which he's now discarded. It would make sense to me, in my mind, that this deputy, this officer, doesn't know what this guy has. And if he takes a moment and lowers his gun and goes, "Hey, let me check, let me see your hands really quick." In this kind of a dynamic, very fast moving encounter, you don't always have time to do all the things you would like to do ideally in the real world, because he's got to make a decision very quickly. Am I going to allow this person to get all the way to me now that he's discarded this bucket? Perhaps he has armed himself. Perhaps that knife is still on him. I don't know. Right. But I have to make a split-second decision that's going to affect this person's life and probably mine for the rest of my life. At the end of the day, I think the suspect forced him into this position. Was this a suicide by cop? Potentially, maybe, possibly. I don't know. But in that position, the officer doesn't have time. And remember the fisheye lens effect. These badge cams have a fisheye lens, a wide angle lens. So it's kind of like the right side mirror on your car. Things are, closer than they appear. That's very much true of these badge cams. These Axion badge cams have that lens so they can get as much of the field of view as possible. Remember that what you're seeing on the tape is not always, in fact, it's never exactly what the officer sees with his, as John calls his Mark 1 Mod 1 eyeballs. He's seeing this with his eyes and perceiving as more depth of field. He can see things you can't see with a camera. So he knows this guy is now, when we froze it on the tape where we showed it on the ASP channel, it looked in the tape like he's maybe 3 yards away. He's more like 3 to 4 feet away, at which point he's on top of him. With an edged weapon attack, we talk about the Tooler drill. A lot of folks have heard of this 21-foot rule where, if somebody's within 21 feet, the odds of you getting a gun out and on target and getting effective fire to stop a person armed with a knife is not likely. The momentum is going to carry them. If this guy was armed with a knife, which is not unreasonable to believe that he was, he's already going to do damage. He's already going to get there in time, even if you shoot him 3 or 4 times in time to potentially cut you up pretty bad. Edged weapons scare the crap out of me. I've seen them, the effect of them on the street. Numerous occasions. We've had videos on the channel of someone who, with one very quick cut, cuts a carotid or ephemeral artery, and the person's dead before they hit the ground. So I think this was justified for those reasons.
So it's more of a totality of the circumstances here, correct. Right? You can say, "Oh, this guy didn't." It turned out that he didn't have his knife on, like he wasn't trying to stab this deputy in the moment, even though he had stabbed a dog and killed another person by stabbing them earlier. But the deputy didn't know that, didn't have any way of knowing that in the moment, right? This was fairly reasonable to assume he may have a knife on him given the circumstance. And this is a physically fit, athletic build guy who's coming after him, somebody who is capable of inflicting a lot of serious bodily injury on him. He's charging into the officer despite the fact that he had pulled his gun. Another perhaps one of these things by themselves maybe doesn't justify it, but all of them together, right? Is that sort of the idea?
Yeah, that's how I would look at it. So we're expected in law enforcement to, the law will consider as you said, the totality of the circumstances. So not just one individual fact by itself. but what would a reasonable officer or deputy believe was potentially the risk of him being harmed or killed in that situation. And I think he was justified in what he did. And again, to your viewers and listeners, I completely understand how you could see things differently. This is just my perspective from someone who did this for a long time. Frequently, we will have episodes on the main channel where, we'll say an officer or deputy was absolutely not justified in what they did. That happened not long ago again in Florida, where there was strictly a physical confrontation. There'd been no violence ahead of time. And they tried to get this guy into custody. They tried a taser. I think they tried pepper spray. They tried jujitsu. Nothing was working. And a deputy in that case introduced a gun when it wasn't really justified. And then when the individual sort of lunged at him, the deputy's defense was, well, I shot him because he was coming for my gun. Yeah. That's a different story. So, I really encourage people. It's not
always justified.
Yeah.
But this particular incident, the circumstances suggest it was. And this is, we'll have you back on, right? Or someone from ASP back on in the future, maybe once a month, hopefully, if we can keep it up. And you'll have a different video for us, different lessons next time around, right?
Absolutely.
And look, we didn't get into everything you guys talked about in this video during our segment. So I think people should go and check out the full video over on the Active Self-Protection channel. And also you can, of course, sign up for the ASP Plus, Active Self-Protection Plus app, which has even more stuff in it, exclusive content. So look, I appreciate you doing this. And, if people want to find out more about ASP, where's the best place to do that?
Yeah, Active Self-Protection on YouTube is kind of our bread and butter. We have the Ask Plus app as well. Check that out. You can see the video version of the Gutowski files over there, which I highly recommend. Is you get to see Steven's visage, his handsome face, for an even longer period of time. And just a side note, I've really appreciated Steven coming on to our podcast and getting that great content over there to a lot of people who might not otherwise know about the Reload. I think Reload's a fantastic resource, and we appreciate what you're doing over there, Steven.
Well, thank you so much. And I appreciate you as well, Mike. This is very positive ending to the episode after watching a pretty hard video to watch, right?
Absolutely.
So I guess that's a nice ending to it. But that's all we've got for you guys this week. Other than my message on the Dispatch, another great resource that people should check out. I'll tell you about it right now. All right, folks, it's time to talk a little bit about the Dispatch, doing an ad swap here between the Reload and the Dispatch. And I think that's fitting because if you like what you're getting from the Reload in terms of high quality reporting that focuses on hard news, you'll probably like the Dispatch as well, because get this, they also focus on high quality reporting and hard news. Now, they are a much broader publication than the Reload. We obviously focus on one specific area, whereas the Dispatch has a much larger team and is able to focus on a whole number of other issues, but still primarily in that national politics realm like we do here at the Reload. But they are one of my favorite publications. I am a paying member to the Dispatch, and so clearly, I highly recommend it. I've been a paying member since they were founded, and I've never had reason to rethink that even once. So they are constantly breaking news stories. They are sending you newsletters on whatever frequency you want. They have quite a variety of them over there. But I subscribe, for instance, to the Morning Dispatch, and I get, I think, a very nice summary of what's really going on from a pretty sober perspective. That newsletter is hard news, and it's focused on it, and I think it's fantastic. But they also, of course, have some of the best commentators, in my personal opinion, over there as well. It was an outlet founded by Steve Hayes and Jonah Goldberg, two guys I've known for a long time. They've been on the Reloads podcast. Kevin Williamson as well has been on our podcast. So you've heard from these guys if you've been a Reload listener for a while here. And, I think you should check out the Dispatch if you haven't already. We have a free trial as well, 30-day free trial for Reload listeners if you want to go over and check out their paid offering. which I think is well worth the money. So I'd encourage you to do that. There's a link in the description of this podcast or on our website if you want to check it out. So head over to the Reload or to get that link, or head over to the Dispatch to see what they're all about.